This constitutional law lecture covers the Equal Protection Clause and due process. Friendly reminder that constitutional law only applies to state or public actors. This means individuals or governmental organizations that fulfill a government function are state or public actors. For example, Minnesota State University Mankato is a public actor, so as a staff member, employee, or student, your constitutional rights should be protected in that setting. Same for the Veterans Affairs Hospital. In comparison, Skyhawk Sports is a private organization in which you may not be guaranteed constitutional rights or protections in their organization because they're private. That being said, there are some private organizations that can be considered state actors through the public function theory, which means that a private organization takes over some governmental responsibilities, or through the nexus entanglement theory, where a state actor and a private organization work too well together or too embedded with each other, and therefore that private organization becomes a little bit more of a state actor. So for example, state high school leagues perform a function for the government. Even though they are private, they manage all the high school sport in specific states. And there are many, many public high schools in most states, so state high school associations have often been considered a state actor, even though they're private by the court. The 14th Amendment contains the Equal Protection Clause. It was created following the Civil War and originally designed to help newly freed slaves receive equal treatment from the government. The several protected classes include race, national origin, religion, and color. These are also known or referred to as suspect classes. When an equal protection case comes in front of the court, there are 3 levels that the court can use to apply to help guide an outcome. Strict is the highest level of scrutiny. It's generally used when suspect classifications like race and national origin are involved. So when a person brings a lawsuit before the court and is claiming that they were discriminated on and their equal protection rights violated because of their race, this is the level that the court would use. In a case like this, the government needs to prove their action, their law, their rule, or whatever was necessary for a compelling interest. So whatever the government did, they need to show that there was no other way that they could achieve the goal without this thing that they did. The next level of scrutiny is intermediate. The court uses a medium level to analyze the case. It's used when gender discrimination is alleged, and in that, when a case comes forward, the government has to prove their actions, their rule or policy was substantially related to a goal. So let's say a state high school association created a policy in which female athletes could not participate if they became pregnant in high school sports. The state high school association would need to show what the goal was and then show how that policy of banning pregnant student athletes related to whatever goal they had in mind. Rational basis is used when non-suspect classes are involved, so something like age. And the government only needs to show that there is a legit reason for the rule in place. Under the 14th Amendment, there are 2 types of discrimination that may prevent equal protection. The first we'll discuss is de jure discrimination. This is a law or policy that has a discriminatory purpose. So the case listed here, the Louisiana High School Athletic Association, essentially segregated competitions. So white high schools only participated or competed against each other, and black high schools only participated and competed against each other because the State High School Association created a policy that said you can only compete against people of the same race. Okay, ultimately, the court determined that this was illegal. In comparison, de facto discrimination is a rule or policy or a law that's not necessarily trying to ban certain people, but it ends up doing it anyway. So it would be maybe creating a district that in your state in which unwittingly segregates people based on race. They didn't mean to do it, but it ended up happening anyway. The 5th Amendment includes the Due Process Clause. These are legal proceedings to ensure fairness and protect individual rights and interests. The clause is triggered when some governmental entity interferes or deprives with your due process rights. If a due process case comes in front of the court, usually a person is alleging they were deprived in one of these three interests. Okay, the first is a life interest. This happens when someone is sent to prison or sentenced to death. The next, which is a little bit more common in sport, often means damage to reputation that prevents a person from getting a job, or some sort of damage to the reputation that prevents and limits their career prospects. The third is more common, a property interest. This, for example, could be physical therapy or occupational therapists licensed to practice. Let's say they broke a rule at the hospital, the VA hospital, and then they were suspended immediately. They could argue that they were deprived their property interest, they don't have their license anymore, they can't practice, and unfairly. Or something like a college scholarship would also be a property interest. So the Fifth Amendment's due process rights start when there's state action. And as a result of that state action, one of your three life, liberty, or property rights was deprived, and that your due process was also violated when the right was deprived. So you weren't given any warning, they just stripped you of your license and you couldn't practice any longer. In a procedural due process case, it comes forward because a person is challenging the way the rule was applied by the state actor. The goal would be, for any of these rules, to ensure fair treatment of individuals and a consistent application, which goes back to ensuring fair treatment of individuals. So someone is saying that this rule that exists was applied incorrectly. A substantive due process case challenges the content of the rule. It basically says the rule is unfair, it doesn't have a purpose, and state actors need to provide a rational basis for that rule existing. Otherwise, it may fall under a substantive due process lawsuit. Here are the minimum due process guidelines. First is that a statement of violations is sent to the person who violated the rule or policy at the organization. Then there is a notice of the potential sanctions for violating that rule. And then the person gets an opportunity to comment and explain what happened. These are the maximum due process guidelines when a major violation occurs. A person is given written notice of a hearing and a written statement of the charges that they're alleged to have done. They get a right to a hearing, and then they get a right to those hearings to be recorded so they can listen to it back, and they have the right to appeal whatever outcome occurs. Constitutional rights are only protected from interference by state actors. State actors exist in settings like public schools, public universities, public hospitals, and public health care settings. This lecture covered the 14th Amendment, the Equal Protection Clause, as well as the Fifth Amendment and due process.